When I wake up in the morning, the first thing I do is reach for a fresh, cold glass of oat milk. But choosing the right brand of oat milk is becoming challenging with more and more companies entering into this multi-billion-dollar industry. Cue the Battle of the Oats and this week's episode of Stuff You Should Know About IP. Today's episode of Stuff You Should Know About IP is brought to you by the Trademark Lawyer magazine. If you want to stay up to date with everything that's going on in the world of IP and trademarks, go to www.trademarklawyermagazine.com. Each issue is free to read for up to 8 weeks. That's trademarklawyermagazine.com for global news in the world of trademarks. Okay, so Tom, Mark, please explain the Battle of the Oats to the listeners at home.
Okay, before we do that though, Ray, you have to explain. I understand that Mark drinks oat milk, but do you really reach for a glass of oat milk in the morning?
No, but I thought it would be entertaining.
Okay, good. Okay, all right. So
I like oat milk. I prefer regular milk, but I'll drink a glass of oat milk.
I have a carton of oat milk in my fridge. My daughter drinks it all the time. I have yet to try it though. But after this podcast, just like when we did the Impossible Burger and I went right out to Burger King and bought the Impossible Burger, I'm getting a glass of oat milk after this.
Now I want some. I want to taste both. We could do a little taste
exactly.
test.
Hey, so anyway, we have Mark with us because Mark is our guru. He's our resident guru on Oatly versus Glebe Farm. And basically, just to kind of give a high level of this, Oatly is this big giant company. They're like a $12.5 billion US dollar valuation, even though I think they're out of Sweden, Malmo, Sweden. And Glebe Farms is literally a brother-sister combo. It's Rebecca and Philip Rayner. And they're out of the UK, which is home to the great Mark Caddle. Did I say your name correctly, Mark?
Yeah, that's correct. Mark Caddle, yes.
Mark Caddle. The great Mark Caddle is in the UK, right next door to Rebecca and Philip. And when I say next door, I mean they're on the same little plot of land. But anyway, so apparently Oatly did not like the fact that Glebe Farm came out with an oat milk and called it pureoaty. So they sued them for trademark infringement. And here we are. Mark, what is going on?
Yeah, that's a great introduction to this, the Battle of the Oats, Oatly and Glebe Farm. I mean, this is a classic David and Goliath battle with some common topical trends around the shift from dairy products to oat milk and the way that has become a big market here in the UK and by the sounds of things in the US as well, if you've got some situated in your fridge. But here we have Oatly trying to enforce their trademark registrations in Oatly against Glebe's use of pureoaty. And the decision.
They actually have a trademark registration for Oatly.
Yes, the word
for
Oatly for oat milk. That's correct. And they also have, you may have seen their product, they have trademark registrations for the front of their packaging as well.
It's like we call it trade dress in the US.
That's it. Yeah.
Would you call it that in the UK as well, Mark?
We tend to call that maybe packaging design or a logo trademark for how something looks applied to a particular product. But yeah, trade dress is the right term for the US, at least in my experience. So they tried to stop Glebe Farm Foods using the trademark pureoaty based on their registrations and their reputation, and also their unregistered user rights, which we have in the UK, a bit like in the US for pureoaty. So that's why this case got off the ground.
We have a registered. Okay, so we have a registered trademark for Oatly. Mm-hmm. Do we have a registered trademark for the packaging as well?
Correct.
And then we also have something unregistered. In the US, we call that common law rights.
Yeah.
And what's that for? So we have Oatly that's registered. We have the packaging on the front of the carton, but then we have this unregistered thing. What is that?
Yeah, so in the UK, we also call them common law rights. Our systems traditionally are quite aligned in the UK and in the US. So we tend to refer to this as being the law of passing off, where you try and hold your product out as being related to someone else when that's not the case. And there's certain tests for that, one of which is that the trademark that you're relying on the unregistered rights for has goodwill, so it's become quite popular, people know it, and you, the trademark infringer, the person that is defendant in the case, has used that trademark in a way that's deceived the public. People are confused. They're buying Gleeb's products thinking they're Oatly products, and that's where that unregistered rights thing kicks in. So that might be quite similar to the US, but it's an additional right.
So I think we had a momentary pause.
Which relied on. Yeah, something in addition to what they could rely on their registered rights.
Thing. All right. So, Mark, what I understand then is it all comes down to confusing similarity, right? That's what we're talking about. The marketplace is confused, or Oatly is alleging that by launching a new oat milk product, which is the same product, right? I mean, same basic product line, with the name pureoaty, it's going to be confusingly similar in the marketplace to Oatly, which is a registered trademark, and maybe the box itself might even be confusing depending upon how people weigh in on that.
Yeah, that's a great summary. There is the test is whether or not people are likely to be confused. Oatly says the registered trademark Oatly is too close. Sorry, pureoaty trademark is too close to Oatly. People will be confused. The registered trademark rights kick in. That was the basis of the confusing similarity claim.
So what did the court say? What happened?
The court was quite dismissive of Oatly's position. Oatly were unsuccessful on all grounds, so likelihood of confusion and the common law rights that we spoke about before, and also their reputational ground as well, which was that their trademark is so famous that use of pureoaty would sort of tarnish and dilute that reputation, a bit like you have in the US. The court said that none of those particular tests were satisfied, and as you've alluded to already, the fact that Oatly is consumed by the word oat, and the only similarity in the pureoaty trademark is oat, their commonality was in their descriptive elements, oat for oat milk. And because the ly ending for Oatly wasn't present in Gleeb's trademark, there was no confusion. No one would think that pureoaty and Oatly were related. So it couldn't apply, and Oatly were unsuccessful for that reason particularly.
So I'm wondering, Mark, how did Oatly get a trademark on Oatly, which seems for oat milk, which seems descriptive to me? Now, in the US, we have, 4 categories of trademark significance. We have fanciful, arbitrary, suggestive, and then we jump the line to descriptive. And unless you have something called secondary meaning, you can't get protection on descriptive marks in the US. But it seems like they got a mark for Oatly for oat milk. That seems unusual to me.
Yeah, I mean, in the UK, the test isn't on the similar tiers. A trademark is either distinctive or not distinctive, unless it has acquired distinctiveness through its use. But these trademarks were inherently distinctive. So when they were applied for, the Trademark Office took a decision that Oatly, and probably the conjunction of oat and the end in ly, would be new enough to be registrable. It was distinctive enough. So in the UK, the decision was that these trademarks were sufficiently distinctive and got on the registration for that reason. But what this case demonstrates is that where the common elements of 2 competing trademarks are in their descriptiveness, so both have an oat, the earlier trademark cannot be relied upon to stop the descriptive use by someone else. This might be where this case is interesting, because we find a decision from the court that says Oatly trademark is well and good, but they can't monopolize the theme of oatiness around oat milk products, because everyone should be able to do that. And I think that's why this has captured some attention and questions some of the reasons why Oatly brought this case in the first place, trying to protect their position in the market.
So I have two other questions that come to mind. One is pureoaty. They don't have a trademark on pureoaty, right? They're just entering the marketplace using it maybe as a trademark, maybe as a descriptor, but I mean, they're clearly trying to use it as a trademark, pureoaty, but they don't have a registration.
That's right, no registration. Interestingly as well, their initial brand when they started out selling oat milk, Glebe Farms, was just the term oat drink. So they were just purely descriptive. They were doing what they did. And then they rebranded to pureoaty, and that's when Oatly jumped on them with this lawsuit, this infringement action. But it is still a descriptive term. They're telling their customers that their oat milk is full of oats. It's purely oaty.
Right.
You know where this goes, right? So that is the descriptive point, that they were able to say our trademark is just descriptive. The Oatly trademark doesn't capture it. We should be able to continue as we are. And that's what the court said as well.
So they actually, as part of their argument, said, we're purely descriptive. they're not even holding themselves like, so if in the future somebody comes along with a brand pureoaty for their trademark or for their milk, their oat milk, wouldn't pureoaty, I mean, Glebe Farms have a hard time preventing them from entering the marketplace unless they had acquired distinctiveness through like all kinds of popularity and stuff like that?
Yeah, it would be difficult if they didn't have registered trademark rights, which might be a problem if we're taking that is a descriptive term. One of the things that they might rely on, though, if they do have someone coming to market after them using the same trademark, is the common law rights we spoke about. It could be that someone is trying to pass their brand off as Glebe Farms. In the UK, that might be actionable, and they could try and prevent that from happening if someone's just trying to copy what they're doing.
Except they've already kind of acknowledged that it's just descriptive.
Yeah, I mean, it might be more difficult for them now to do that. But
Mark, the other question that this time you froze. It's okay. This is the other question I had for you is, I did a little quick search and found that there's another oat milk brand which is made by a company called Silk, which they play on the theme of oh yeah, but they call it oat yeah. OAT space YEAH. Oat yeah. So we have Oatly, we have pureoaty, and then we have another brand called Oat yeah. There's no exclamation point, by the way. So, but I'm wondering, is that another one where oat is clearly usable by everyone in the oat milk business, right?
Yes.
And I would say they would probably be okay because they're going to focus their trademark, like significance, if you will, on the yeah, like this enthusiastic thing about oats. So they could probably get a trademark on oat yeah, and they could probably prevail if they're either opposed or, sued by Oatly, right?
Yeah, in that example there, the same logic applies. Oat is being used descriptively to refer to the product. The distinctive part is the yeah part. And for that reason, Oatly would have a tough time trying to get them to stop using that trademark or registering that trademark as well. It's one of the things that's apparent to me here is that oat is becoming more and more widely used in the particular oat drink sector, as you'd expect. And if there is a sort of first big player user like Oatly, it's going to be hard for them to control the use of oat by other people, given it's just a descriptor. So their initial, to go back to your point about Oatly being perhaps on the borderline of what's distinctive, what isn't distinctive, that gives them a harder time trying to enforce the trademark against uses of oat by other people.
Yeah, so let's say pureoaty Glebe Farm comes to you 18 months ago, and they decide, hey, I think they launched their oat drink 18 months ago, and then sometime thereafter they decided to adopt the so-called trademark pureoaty, or maybe a trademark pureoaty. So they come to Mark Caddle, the great trademark lawyer in the UK, and they say, here's what we want to do. I mean, would you counsel them and say, look, let's just back off. We don't have any emotional or financial investment in pureoaty yet. Why don't we pursue a trademark that you can actually have as a trademark instead of something so descriptive that you could probably be infringed downstream? And oh, by the way, you might be infringing Oatly, which is a $12.5 billion behemoth. I mean, what would you say to them if they came to you?
Yeah, probably two things to our advice there. First off is to conduct some thorough searches about what has already gone before to make sure there isn't any infringement risk. And perhaps in this case, if we search for pureoaty, that Oatly may have come out in that. And then maybe if we were taking the line that pureoaty was a descriptor, we might have said it's not going to be an issue because Oatly can't stop use of descriptive terms. The second thing would be around the point you just described there. The best trademarks are those that are unique, fanciful, that really set you apart from your competitors. Although we wouldn't necessarily counsel them on their sort of brand selection, it could just be that pureoaty is quite descriptive. You may wish to think about something that you could register for yourself, give you a big slice of the pie, something you've got a monopoly in that you could then enforce against others to protect your own exclusivity. Because as we spoke about earlier, some of the issues about trying to enforce pureoaty may come back to hurt Glebe Farms in the future. Time will tell, but that's something to bear in mind.
Yeah, I like the way you put that. I like the way you said that you wouldn't counsel them on a brand because that's not your thing. You counsel them on the rules associated with getting protection and enforceability of a brand. Right?
That's right.
And then so then they can get all their big brand experts to say, okay, well, I get it. Let's try something fanciful or something in that regard.
That's absolutely
Yeah.
right. Yeah, we're not necessarily sort of brand advisors or an ad agency, but we would say that if this trademark isn't distinctive, it's not going to be registrable, and all the benefits of trademark registration, being able to sue people, having the peace of mind you can use a trademark, are lost, and you might want to consider something else. Over to the creative guys, and they pick it up there.
Right. Well, so here's one thing I found funny about this outcome. Okay. So Glebe Farm prevails. They get sued by Oatly, this big giant. They prevail. The court tells them it was not uncertain. It was certain terms. They're not infringing, right? They're not infringing. So then the quote I get from Oatly is that we wish Glebe Farm the best going forward. We love you. We want you involved in the market. We wish you the best. We just think they should do so in their own unique voice, just like we did. Okay. So that's their parting shot, is we just think they should do so in their own unique voice, just like we did. Here's what it reminds me of. In the olden days, I used to be what's called an assistant district attorney in my town, and we prosecuted criminals. And I had this buddy named Rich, and Rich tried this petty larceny case. It was like, guy goes into a store, steals some stuff, runs out, gets caught, goes into court. Rich loses the case, okay? The defendant wins the case. He's not guilty. As the defendant's walking out of the courtroom, Rich says, and I never want to see you back in that store. I said, dude, you didn't win. He's not guilty of committing petty larceny. He can go back in the store. That's why I love this quote, which is, they just lost, right? You're not infringing. We just think they should do so in their own unique voice, just like we did. I just think it's such a funny, ballsy, maybe slightly not self-aware. I don't know what I could say about it, but that jumped out at me as funny after the case, But anyway, that's probably also not for us to counsel on, because that's not a legal matter. That's more of a branding matter.
Yeah, and you might have seen as well, Tom, that on Oatly's website, and this is true of Glebe Farms as well, they've actually published the decision and promoted the fact that the case had happened, tried to come clean. On Oatly's website, they've actually got some of the skeleton arguments from the case. They've got a decision links that you can go as a member of the public if you want to.
Wow.
And they seem to just say, this case happened, here's everything that was argued. You can make up your own mind about it. A bit like the quote you just said, almost saying, this happened, make your own mind up.
Good for them.
Yeah,
good for
it's interesting
Oatly.
To see that.
Yeah, I love the fact that they did that. So in other words, they're not hiding. This is what happened. Good for them. I applaud them for doing that. Now, to Glebe Farms' benefit, it's probably giving them much needed notoriety, because they're a small company. And I read an interesting commentary on this. This person was commenting on why Glebe Farms didn't just back down when this started. And they said one reason might be they want Oatly to buy them, because Oatly apparently does not have a processing unit or a factory for processing, or maybe not in the UK or something. Okay. But, so what does Glebe Farm get out of it? Because it costs a lot of money. I mean, you litigate, you're spending, you know what that's like, Mark, right? I mean, you're spending a lot of money defending yourself. So even if you win as the defendant, you still lose because you've lost a small fortune. And if you are Rebecca and who's our other guy here? Rebecca and Philip Rayner, not a huge company. This came right out of your pocket. But they got notoriety, right? They got to know this company, Oatly. Maybe Oatly buys them, and maybe they get investors. I mean, who knows? This could become a big boon for Glebe Farms. I mean, they won, but the money they lost, they might get back in other ways, like brand development, recognition, sympathy. People say, "Oh my God, the little guy lost. I love the little guy. I'm going to start buying. I'm going to get Glebe Farms pureoaty in my fridge." Maybe that happens. But Oatly handled it brilliantly, because now I'm not upset about Oatly anymore in light of what you've said. They came clean. They put it all out there.
Yeah. I mean, that's one thing that nowadays, at least in the UK, probably the same in the US, given the same trends on social media platforms and the sort of court of public opinion, a lot of PR is generated around this case. I mean, one of the things that happened was that Glebe Farm, they started a petition, or at least someone started a petition on change.org, and that had 130,000 signatures. And they ran the strap line, "Let Glebe Farms sow their oats." People that were essentially coming coming out and support of Glebe, and everything you said there about PR and generating a bit of a storm around this to try and favor the little company, as you said, family-run farm, basically farmers running a company in a small part of the UK. All good PR for them, I would say.
Yeah. And of the 130,000 people that signed the petition, I would guess that 129,996 have no idea what this case is about. Yeah. They don't understand the subtleties of what's actually happening here, but they're supporting the little guy. They don't care what it's about. They're like, hey, we want to defend the little guy.
Yeah, that's it. And I think that's the right conclusion to draw, that they've basically created a bit of a hype around the brand by not really doing much other than defending a court action, which if they got advice at the start, it may have been, you've got a good chance of winning this, let's see it through.
And they did.
Tactically use some of the good PR, and here we are talking about it now. So they're still getting spoken about. Now they're in the US. So great news for them.
And they're going to have now millions and millions of people that watch our podcast are going to be probably thinking about Glebe Farms and Oatly. They're both winning.
If you're not craving a cold glass of oat milk by the end of this podcast, there's something wrong with you.
I agree. And as soon as we close, Ray, I'm going into the fridge and getting myself some oat milk. But
I know I'm going to go run
I'm not going to do that. I'm going to go to Wegmans, which is the greatest grocery store in the world, and it's right down the street from me. And I'm going to specifically support Oatly and Glebe Farms and buy milk from both of them today and test both.
We'll do a follow-up on this episode.
You got it. But Mark, this has been great. Thank you so much for doing this today.
Yeah, Mark.
You're very welcome. It's good to speak to you both. Hope you found it useful.
Yeah, and for all of you out there, you millions of listeners, if you enjoyed this podcast, please don't forget to hit the subscribe button, like, share your comments, send it to your friends, your family, your in-laws, and support stuff you should know about IP. Thanks, everyone.